Morning, everybody, and welcome to the District of Columbia Court of Appeals. We have one case on this morning's special sitting calendar, and it is number 23 FS 1042 RE E.A. Whenever you're ready.
Good morning, and may it please the court. Ariba Jabril on behalf of Appellant E.A. I would like to reserve 2 minutes for rebuttal.
Okay.
This court must reverse E.A.'s adjudication because the government failed to present specific and objective facts establishing reasonable articulable suspicion that E.A. was involved in criminal activity or that he was armed and dangerous. The government's case against E.A. is dependent on the admission of radio dispatches for which they have failed to provide sufficient information regarding the underlying basis or source. The Supreme Court in Hensley and this court in TLL and RW have made clear that where an officer is relying on a dispatch to effectuate a stop, the admissibility of any evidence recovered is determined by whether there was reasonable articulable suspicion at the source of the dispatch, where, as here, the government has failed to present sufficient evidence regarding the underlying basis or the source of the dispatch from which the court could make an independent determination of whether there was reasonable articulable suspicion, the dispatch must be excised from the court's reasonable suspicion analysis.
But how realistic is it to expect there to be the kind of detail I think you're talking about in a dispatch? Like where do you draw the line? I understand, both sides submitted 28K letters about RW. That seems, quite a bit different from what we have here.
I think that it's important to know that when we're talking about detail, we're talking about the information that needs to be presented to the court rather than the information that officers need to know in order to be able to effectuate a stop. And when it comes to the point of information being presented to the court, we just need to know specific and articulable facts that help enable the court to make an independent determination of whether there was in fact reasonable suspicion. And so this information can't be assumption, it needs to be fact.
How far back do you have to go with that? For example, suppose at the suppression hearing, the government had brought in the officer who took the report from a citizen of having been robbed. Is that all we'd need, testimony from that officer that citizen X told me she was robbed? Or do we need citizen X in the court too, so the judge can determine whether or not citizen X made a believable report to the officer? How far back do you go in making the point that you just made?
We don't need to have the victim present in the courtroom, and we don't even necessarily need the officer who took the report. We just need to know information about what the victim said, what they heard, what the basis of their perception was, and what the officer's perception was of that incident. And so you can take the example that comes from the dispatch here. From 1367 Hamilton, there's the dispatcher, what we hear is tried to take something but unable to. That sounds like robbery, except there's a lack of specific facts to understand what it means when someone tried to take something. We know this dispatch probably came from an eyewitness because in a later dispatch, we hear someone say in Exhibit 2B, still trying to locate the complainant for the first one. And so we know this probably came from that eyewitness. What did that eyewitness actually see? Did they see two people or a group of kids having an argument and she thought someone was trying to take something? Or was it the complainant, or was it someone who was a friend of someone who had a tug of war with someone who actually tried to take maybe their purse or something? And we know that these people had no relationship with each other because we know that the witness knows and understands.
But let's say that the officer who heard that complaint initially and took the complaint comes in and says, well, she told me this. She gave me some details of what occurred. And obviously the judge would have an opportunity to evaluate the credibility of the officer testifying, but also obviously doesn't have the ability unless the victim is there to evaluate the credibility of the victim. I mean, how far, I just don't know how to draw the line with respect to how much has to be presented to the judge as a basis for determining whether there was reasonable suspicion.
I mean, even if the victim isn't there, the officer who knows the basis and understanding of what was going on with the victim can still be asked questions by the defense attorney, for example, right? What was her demeanor? Did she have a relationship? What was going on? And so there's still room for that kind of conversation that would allow for additional facts to be adduced that the judge can then understand what was going on. If what the officer gets up and says, oh, she was confused and she said there was a big crowd and someone bumped into her and it seemed like someone was taking her phone, that would be an entirely different scenario. And I think the judge's understanding of that scenario would be entirely different.
I mean,
Well-
whatever doubts you could have on the face of the radio runs about maybe this was a misunderstanding rather than a robbery, why aren't they laid to rest by what amounts to a police chase? You know, the people in this car are fleeing police. They're driving through stop signs and lights. They crash the car. They get out and run. Whatever you might have thought about, you know, this possible attempted robbery report and, you know, some unclarity about who was involved in it in the radio runs, at that point, you've got no doubt, at least reasonable articulable suspicion to think, all right, this isn't a misunderstanding. These people are up to serious criminal activity, because who drives like that, who crashes, and who bails out of a car and runs from police officers if they're not engaged in serious criminal activity?
I think allowing for flight to be a post hoc justification for the information that was in the dispatches would further broaden what already is an intrusion on the Fourth Amendment. And so in Hensley, the court recognizes that.
Don't try to, what's the intrusion on the Fourth Amendment that's already occurred? That
So-
they're tailing the car?
No, so not tailing the car. So when an officer is effectuating a dispatch, they're relying on incomplete information that other officers have. They don't personally have the reasonable articulable suspicion. And so but Hensley allows for them to do that, recognizing that, and Whiteley recognizing that there are times where that can result in an infringement upon someone's rights because,
I'm sorry, I don't understand.
yes.
The dispatch is an infringement of their Fourth Amendment rights?
Sorry, no, I think I may have misspoken. It's not that the dispatch is an infringement, it's that allowing for a dispatch where there's incomplete information and letting other officers rely on that can lead to more potential and more room for illegitimate seizures because there's incomplete information, because officers are inherently operating on incomplete information.
But what I'm suggesting is
Mhm.
the information has been sufficiently completed by their personal observations of
Okay.
the car fleeing, crashing, running stop signs, I think lights as well, and people bailing out of the car. So, you know, whatever doubts, you know, this is not, RW is a totally nondescript call about a suspicious vehicle with no details about what that suspicion is. If RW were coupled with, there's a suspicious vehicle going up the road, and then you get up to it and it's running lights and it crashes, suddenly, whatever you think about the concreteness and lack of detail in the radio dispatch, you would think, well, I've now verified that this car has people who are engaged in some pretty serious criminal activity.
I think that creates a separate rationale and a separate basis. It doesn't corroborate what came before. And we know that from TLL. In TLL, there is a complaining witness who describes being robbed, but then we also have this address. There's no source for the address. We don't know where it came from. When the officer arrives on the scene, the people who are on the porch, there's between 5, 10, maybe even 15 people, they run.
I don't understand. I don't understand what you mean when you say it doesn't corroborate what came before it. If you've got a call that says white Nissan,
Mhm.
on a crime spree and committing robberies, and we don't know what the source of that is.
Yes.
And then you see that white Nissan engaged in what looks to be flight from police, reckless driving, crashing, everybody bailing out of that car. Why doesn't that corroborate what is uncertain about the previous calls? So verification that what these people are up to in this car is clearly criminal activity. I've seen it.
I mean, the criminal activity that the officer sees is definitely a traffic violation for sure, but whether that amounts to robbery, there's not necessarily a connection there. It doesn't corroborate that specific fact. So it
I don't-
creates a separate independent.
I don't see how. I mean, do you not think it's a fair inference that people who blaze through, you've got some inkling that a car,
Mhm.
maybe it's not the right car, maybe you just get a white Nissan, is engaged in several robberies. That's what comes over the radio. Then you see a couple white Nissans, some are acting normally, and one is blazing through lights and crashes and people bail out. You wouldn't think that was corroboration that that's the car we're looking for?
I think that I think there, because the facts are so unrelated, each fact has to have its own underlying basis or source. And so flight on its own can create additional suspicion or a separate suspicion. But to say that flight, which is not exactly the same thing as the taking of something, can corroborate the taking of something that amounts to a robbery, I don't think those things are.
Seems to me that we could set aside the dispatch about the
Yes.
robbery and we could rely, and the court could rely on the testimony by the helicopter officer that he saw this car going through stop signs, going through red lights, driving in the wrong lane, trying to pass people, etc. There was definitely a reason to stop this car. And there, I think, was a reason to handcuff the people, having seen that they bailed out and were trying to run. So it seems to me it might come down to whether or not there was a basis for patting EA down and locating the gun. And I know that the briefs argue back and forth about whether or not the gun fell out of the front pocket of the sweatshirt before the officer's hand helped it along. But but Officer, is it Duckett, is that the name, testified that he heard the gun clang, hit the ground when EA was rolled over. And the trial court said the same thing. I listened to the video multiple times and I heard it. Seems to me if you credit that, and my question to you is going to be why shouldn't we, or why should we disturb the trial court's finding? If you credit that, then it seems to me you have all you need to justify a search, end of discussion. What's wrong with that logic?
So I think there's a couple points to address there. I think you can excise out the other information and just focus on the traffic violations. When you're doing so, I think it's important to note that EA was not the driver, and Officer Savage testifies that he voiced out over radio that EA was not the driver. And so the traffic violations, they create a reasonable articulable suspicion as to the driver.
Right, but our case law says that, sort of jumping out of a car that's run through traffic lights is pretty good evidence of guilty knowledge about the unauthorized use of the vehicle. So it doesn't matter that he wasn't the driver, I would say.
I think that's fair, but also the case law in this jurisdiction also says that in Posey, flight is not merely a box that once checked automatically justifies a stop. Like any factor in our comprehensive analysis, flight is viewed in the context of the specific facts and corroborating circumstances. So I think that's still valid and a relevant.
I mean, there's flight and then there's flight. This is not an officer approached me. This is not Mayo, where an officer approached me. I said I didn't want to talk, and then they still badgered me, and so I ran because I didn't want to deal with them. This is a violent police chase that ends in a danger. I mean, it's very dangerous behavior, putting lives at risk. I don't think it's just civil infractions, easily criminal infractions on reckless driving. So this is not your typical, doesn't really fit into the box of flight. So I mean, I guess I want your reaction to that. I also think it's not quite right, but tell me what your source is to say that at the time of the stop and frisk, Savage has radioed out that EA is not the driver. By my timestamps, I had seen that comes after the stop and frisk of EA. It's not clear that he's not the driver at that point. They don't know which one is the driver. A bunch of people bail out. So I mean, I'm looking. I had Government's Exhibit 2 at 1627. That's the moment they bail out. It's not until 1935, so that they identify the driver, and that's about 10 seconds, I think. Well, a minute or two after they stop EA.
So I think 2 points in the testimony, Officer Duckett testifies at 1:53, that was broadcast over the air that the driver, I believe, had ran in a different direction. And then Officer Savage says, and you notified officers that the individual that went towards the northwest, that was the driver of the bailout, the vehicle. And the answer is yes, that was correct. And then I believe that the testimony, the radio run, the portions of the radio run that were admitted were up until minute 17:50 seconds. Wrong on that. And I think there's a little bit of room for confusion here, because when you're looking at the actual exhibit list, the court reporter didn't list government exhibit 2 in the index, and so there's a bit of confusion in that transcript. And then when it comes to flight, you characterize this as a police chase, but the officers repeatedly say that they're not in pursuit. That's repeatedly said in Government Exhibit 2. And so I don't know that it's fair to describe it as a police chase, but yes, I agree that Officer Savage testifies that it was going extremely fast, or fast rates of speed, completely going through signs and stoplights. That's true.
Can it be made a police chase if if they're aware of the helicopter and they're that's what's freaking them out?
If they're aware of the helicopter, then that kind of changes the calculus a little bit, because then it becomes a little bit more like provoked flight, because then they're afraid of the helicopter, and so maybe they're driving erratically because they're freaked out by this helicopter. And so that might, open up the possibility of, more innocent reasons for that flight, or maybe just more teenager-like behavior, like they're driving erratically because they're freaked out and they're scared, or because they're teenagers and they're driving erratically. And then, but even if we take that flight and we go to the pat down, even if we take that flight and we go to the pat down, there is a debate about whether or not the pat down occurred. In Mayo, this court specified that the appellate court has the responsibility to review the evidence in the record, and the evidence in the record, I've never heard that sound. The judge says that they've heard that sound of clinking. And I think that Officer Duckett's testimony on direct, what he says when he's being asked about this, on cross, what he says when he's being asked about this is that that he doesn't really remember very well, right? He says, show me the video. That's what I know. And when
He says, I heard the object hit the ground as soon as we rolled him over.
He does say that. And then on cross, he says, on cross, he is asked more information about the video. And he says, my recollection of the video comes from, or is my recollection, he says, I don't really remember. Can we play the video? I want to see the video. And so I think there's an inference there that we should trust what's going on in the video more. And then when he's asked about it, he says it comes out just as I'm turning him over. But when you're actually watching the video, you can see that he's like being held up and propped up on his side. And then you can see that Officer Duckett first pats, EA's front side pant pocket, and then it goes into his front sweatshirt pocket. So it doesn't look like a swift movement of just turning him over. And when he's trying to turn him over, he's holding him on his side, on his shoulder. But then when he holds him there, and then his hand goes to his pant pocket and inside, on the sweatshirt, and then inside the sweatshirt pocket, that looks more like a pat down and looks more
It
like a
doesn't
search.
seem like it doesn't fall out actually, right? Which is what he says on direct, which I realize he backs off from. But is it, I do feel like you might be able to hear a sort of scraping sound. Do you hear, is that when the gun, you can see it slide across the pavement or something? I'm not sure what that sound is.
I think later on when it's actually out and it's been pushed out and you can visibly see it. But I also want to note that there's a lot of noise, there's a lot of screaming, there's handcuffing, there's a lot going on there. And so it's hard to tell exactly from the video, but I don't hear it before that moment.
I mean, that would not be a basis to say it was clearly erroneous to credit the officer's testimony that he heard it, though.
No, but it doesn't make sense when the judge says there's a finding that there was a pat down. It doesn't make sense for him to say that. He doesn't say there's a pat down and then he doesn't say he heard the noise and then I had reasonable articulable suspicion and then there was a pat down. He says the search, the pat down, and the flip over. That's the order in which the judge goes, which implies that's the order in which he's interpreting the events.
And on
don't-
cross, the officer agrees that there's a pat down, right? But
Yes.
but is it placed? You know, where is it placed or is it not placed time wise?
It's not placed time-wise, but he does say there was a pat down. And then for the pat down itself, in terms of whether or not there was reasonable articulable suspicion for that pat down, Officer Duckett and neither Officer Duckett nor Officer Ariema testify that that EA's actions themselves could suggest dangerousness, and the government doesn't even try to argue that. You know, they don't say that he was making sudden movements or there was bulges or that he was acting threatening or any kind of way. The government only argues that there's a presumption for this pat down on the basis of Hicks, which is, you know, if it
On the basis of what?
of Hicks, which is so basically the government only argues that there's a presumption that EA was dangerous because there's reports of robbery, but that's what if you are only finding reasonable articulable suspicion for the traffic violations, then that logic can't follow. I think if the court has no further questions, I think that is.
Okay, we will give you a couple minutes on rebuttal. Thank you.
Morning, Your Honors, and may it please
Morning.
the court. Xavier Ritchie for the appellate of the District of Columbia. In this case, victims reported 2 robberies that were blocks apart and that involved up to 4 suspects in a white Nissan Rogue with specific plates. 25 minutes after the last robbery, the same white Nissan Rogue was spotted 10 blocks away in a residential part of Kansas Avenue. The car then fled unprovokedly, violated various traffic laws, and ultimately collided with another car.
Can I interrupt you there? Sorry, when you say fled unprovokedly, sounds like you're talking about Wardlow very specifically or something, but what in your brief, you suggest that the car was actually fleeing from the presence of police, even though there seems to be a lot of, or at least some testimony that it wasn't in, the police were not in pursuit of it at the time. How do you reconcile that? Was this a police chase?
It's our position that this was not a police chase. Unprovokedly, when we say unprovokedly, we're arguing that once the appellants in the car, once the appellant and the drivers, once they saw the police presence, that's when they decided to flee without any reason.
Okay, so when you say in your brief that the car in which he was traveling fled from the presence of police,
Correct.
that's wrong?
No, that's correct.
Oh.
There were, as the officers testified, there was not a chase. And as the exhibits also indicate, and I think on the radio run, the ground officers, once they say that this is not a chase, that they have not put on their lights, that the car decided to flee unprovokedly.
Okay,
So you're saying they weren't approaching, but they were spotted
Correct.
and that prompted the fleeing.
Correct.
Got it.
Correct. They decided to flee. And so after the car ultimately collided with another vehicle, appellant had bailed after the crash with one of the suspects who matched the precise description of someone mentioned in an earlier lookout. And the officers later found appellant hiding in a basement stairwell, and after handcuffing him, saw a firearm slide from his hoodie pocket. So it's our position that the seizure of appellant's firearm was justified under the Plainview Doctrine, which was a product of a lawful Terry stop, and the court should thus affirm. So I
Do
can
you
get in.
think the videos substantiate that the gun just fell out on its own and was in plain view?
Yes, we do. Immediately, so at 17:23:35 of Officer Duckett's body worn camera footage, that is at the point where the appellant is on his side and he has been completely rolled over. And immediately at that second, so this all happens extremely fast. And at that point, you can see the appellant look immediately down to his torso area, to where the hoodie pocket is. And at that point, you see Officer Duckett put his hand down into the area of his hoodie pocket. And Officer Duckett testified that it was at that point that he saw the firearm on the ground. And although the body camera footage might not have picked up the visibility of this firearm until seconds later. That's what Officer Duckett said, and that's what
I'm
the
sorry,
officer.
what's your timestamp?
17:23:35.
Okay, because you excerpt a picture at 41 in your brief, which I found a little deceptive because you've omitted that the search has already happened. The hand is right there and you crop it out. So I would, I think if you're gonna take a still frame from a video, you ought to include the entire still frame and not crop it out. But you're telling me that if I look at 35, I will say I've looked and I didn't see it. But if I look closely at at second 35, you can spot the gun?
You can't spot the gun on the video camera, but Officer Duckett testified that it was at that point the firearm immediately slid out of appellant's hoodie
Okay,
pocket.
I thought Judge Thompson's question was, do you think the video evidence bears that testimony out?
Well, there is the sound of a metal clank, and we also think that corroborates.
Did you
Officer
hear it
Duckett's-
in the video?
Yes, we did.
I listened, I didn't hear it.
So that
The
you-
trial court heard it.
Yes,
Officer Duckett said he heard it. You
Yes.
also heard it.
yes, we heard it, and there are also other sounds, but we think that metal clank is pretty distinctive.
And is your point that Officer Duckett could have seen the gun even though his body worn camera didn't pick it up?
That's
didn't
correct.
show it?
That is a possibility. Yes. Yes, and Officer Duckett testified that much on page 88 of the transcript. He says that the firearm slid out simultaneously as he rolled appellant over, and that it came out on par with his hand touching the hoodie. And he also testified from what he remembered, upon flipping appellant over, the gun was already visible. So although it might not have been picked up on the camera footage at that point, that's our position, that it was in plain view of Officer Duckett, which prompted him to place his hand down there.
Why were the officers, are you calling this a Terry stop? When they, got Miss EA down on the ground and handcuffed him?
Yes.
And why is that a Terry stop? And yeah. why-
Yes, so based on the facts that I recounted, we think there's clearly a ground for Officer Duckett to have a reason to suspect that appellant was involved in some criminal activity. And we don't think that the handcuffing exceeded the scope of Terry, based on this court's precedent. My friend on the other side mentioned Hicks. In that case, this court said that so long as the person is suspected of committing a crime of violence, statutorily defined as a crime of violence, and under DC Code Section 23-1331, attempted robbery, all of that is defined as a crime of violence. So we think that
Even
gives,
unarmed robbery?
that's correct.
And do you agree that there was no evidence of this being an armed robbery, of either of these being the second one, really, the only information is that there's one woman involved, right? Not the car, not four people. I mean, maybe this is what you would call the third one, but the incident where the woman in the red is involved, that is not, none of these is armed robbery, right?
Well, there's communications over the radio run. So I think you're referring to Exhibit 2B when they're giving the description of this young woman. But in Exhibit 2A, the ground officer who's in the field, he mentions that there's a white Nissan Rogue, that this is a lookout for the same thing. So we think that you could infer that both of these radio runs involve the same white vehicle.
Do you think that the trial judge erred in concluding or stating that that EA was involved in 3 robberies? He might have even said 3 armed robberies.
Your Honor, my friend on the other side points to the 7th and Peabody incident. Our
Okay.
brief does not rely on that incident. We're not going to fight on that point. We think based on the 2 later robberies that that's enough to suspect that that appellant was involved in some criminal activity.
Officer Savage said something about an armed carjacking. You don't rely on that either, I take it. Is there any other evidence that there was an armed carjacking?
We're not relying on the fact that there might have been a carjacking. What we do think that there were enough facts that would allow the court to infer that there was a stolen vehicle involved. Both of the officers, and Officer Savage and Officer Duckett testified that there was either a stolen vehicle or a felony car involved in this incident. And the observations of the officers you mentioned earlier, Officer Savage's observations with the helicopter, we think that those additional observations corroborate that testimony that, hey, this
The
car is
term
driving.
felony car, does that mean a stolen vehicle?
Yes, it does.
It doesn't mean a vehicle involved in a felony in some other way? I'm just not familiar with the term. I saw it in the record. That's what it means?
From what the officer testified, yes, it indicates that it's a car that's stolen and that probably was involved in other crimes. Yes.
Suppose we excise the report of robbery and we're relying on on Officer Savage's observations about the car speeding and going through stoplights and stop signs, as a justification for the stop. Was there also on that assumption, was there also a justification for the handcuffing?
Thank you for the question, Your Honor. First, I'd like to push back on excising any of the evidence that was introduced on the record. Under Supreme Court precedent, the Supreme Court has highly suggested that, or has highly urged courts to not excise information merely because that information by itself cannot establish reasonable articulable suspicion. We look at everything in the totality. So when we consider those runs with everything else.
Well, I appreciate your point, and it's a good point. Thank you for pushing back, but I'm excluding it for the moment simply because your opponent says that the government didn't bring in the evidence that would have allowed the court to evaluate whether there was reasonable suspicion of robbery. So I still want to excise it for the moment, if you
Okay.
let me. Now, my question is, with that excised, and if we're relying just on the going through traffic lights, stop signs, speeding, et cetera, what about the handcuffing? Was there a basis for the handcuffing?
There was a basis for the handcuffing.
What was it?
Well, at that point, appellant had proved to be a flight risk, and also based on Officer Duckett's body worn camera footage, you can hear at, I believe, 17:22:47, you can hear Officer Benson, who was the first officer on the scene, begin to give the appellant demands and the suspects that were with him. But 15 seconds later, when it's 15 seconds later that we see appellant finally on the ground. And I think when Officer Duckett had approached the scene, he was slowly walking up the basement stairwell stairs. And 2 seconds later, just to get to my friend on the other side's argument, that 2 seconds does not cover everything that happened. So we think that that's a ground for handcuffing appellant.
Because he was slow and he was uncooperative? is
Because
what
he was
you're saying?
uncooperative and because he did not immediately comply with the officer's commands. As this court recognized in Catsby District of Columbia, that is a ground for handcuffing a suspect.
Is there other findings on that? Did the judge make any findings on that? When I looked at the video, it just seemed like he was coming up the stairs. I'm not sure how much faster he could have gotten down, but I might be missing something.
Well, I mean, I think it's that in Officer Duckett's body worn camera footage, I think it's telling that when he's finally on the scene, both of the other suspects are on the ground completely, and appellant is slowly walking up. And I think that suggests that
Oh, it was uncooperative because he wasn't already on the ground like the two others were?
correctly, he was disregarding Officer Benson.
Because we don't know that that was because he was disregarding. I thought they were just saying, once the other officer arrived, he took too long to get to the ground when ordered to the ground, but you're actually saying he should have been there already.
Right. And you can hear, as I said, on
Do
Officer
we
Duckett.
know that he had been ordered to the ground before that?
If based on Officer Duckett's body worn camera footage, if you listen to 17:22, beginning at 17:22:47, Officer Benson, who's already on the scene, who's confronting these three suspects, is giving demands for them to get on the ground.
I mean, come on. Part of your argument is that he's hiding underneath the stairwell there,
Correct.
right? So the fact that he's telling people to get on the ground, if you're under the stairwell, one would think, first he wants you to come out from under the stairwell. And so that's perfectly consistent with what I see on the body worn camera. He's coming out from the stairwell, and so he hasn't gotten down on the ground yet, but then he gets on the ground quite quickly. Is this an argument you really want to push? He didn't get down quickly enough, and that would be grounds to handcuff him? Like, clearly the officers didn't rely on that. They were handcuffing everybody, including the ones who got on the ground quickly. Is this an argument you made before the trial court?
We're not concerned with the other suspects. We're concerned with
I
our
understand.
observations of.
Did you make this argument before the trial court?
I believe that.
Failure to
Complicated.
comply promptly enough justifies
Yes, and
the
this is what.
handcuffing?
Yes, sorry, and this is what the officers testified to below. And
Testified to, we handcuffed him because he didn't comply quickly enough.
maybe not based on those observations alone, but also I mentioned earlier that the appellant had proved to be a flight risk. Those three suspects had fled from the car
Yeah,
that
that
collided
part I
earlier.
get. It's the part that he didn't comply quickly enough, which is based on, from what I can tell, nothing. Other than Duckett's approach where you see him, for all I know, coming out from behind the stairwell.
Well, it's how I would describe the stairwell is just a set of stairs that goes to
Yeah.
straight to a door. There's no reason for, like, there's nowhere for him to have.
He's
gone.
underneath, he's at the bottom part of the stairwell.
Right,
You
and
gotta
but it
come
doesn't-
out before you get down, otherwise you're hiding.
Right, and it doesn't take 15 seconds for someone to walk up maybe 5 steps.
I mean, might. That's not an extraordinary amount of time between, when you're talking about coming out from the stairs and getting down. So, you know, now we should announce a rule that if people take a few seconds to comply, that's grounds to handcuff them.
Well, you don't just have those 2 seconds or 15 seconds.
Yeah, I'm just
whatever
wondering why you're
it
relying
is.
on it. It seems like a silly thing to rely on to me.
Because in the totality of the circumstances,
No, that's
he
all right.
proved to be
All
a
right.
flight risk and he
Fair
took
enough.
15 seconds. So we think those facts, even if we excise, which we encourage the court not to do, even if we excise the radio runs, those facts certainly established that there were grounds to handcuff appellant. And as I also mentioned, so if we want to entertain the theory that there was a frisk, we also believe that there were grounds to frisk appellant based on Hicks, the United States, again, because appellant was suspected of committing a crime of violence. That was enough for the officers to frisk appellant.
Can I take you back to the excising? Were you saying that our case law doesn't allow excising because of the totality of the circumstances test or something? Because isn't that definitely what RW does? And I think it relies on case law before that.
We see that that's what happened in RW, but our position in this case is that that's inconsistent with Supreme Court precedent.
RW said it was bound by TLL that did the same thing. It said it was irrelevant. You can't consider it.
Yes, and
So I mean, as far as we're concerned, we've interpreted Supreme Court precedent on the point and that it disagrees with your interpretation of it.
well, TLL was a DCCA case, not a Supreme Court case.
Right.
Yes.
But I mean, there's precedent on precedent, right? The Supreme
Yes.
Court, what's the Supreme Court case you're relying on and what year was it?
United States v. RV Zoo, and that's 2002.
Okay, and TLL and RW post-date that?
They don't reference RV Zoo.
So we didn't consider it, so you think they're inconsistent with that prior Supreme Court precedent, so we should disregard that.
As far as splitting and dicing the facts and not considering some facts because those facts by themselves don't establish reasonable articulable suspicion, yes, we believe that's inconsistent. If the court has no further questions, I see my time is running. We'd ask the court to affirm. Thank you.
Thank you very much. Ms. Jabril, we'll give you a couple minutes.
Thank you. We just, I would just like to make a point on the frisk. So I just want to make sure to point out that the judge's findings specifically say, and he says, quote, "I find specifically that the officers had reasonable articulable suspicion to stop the 3 juveniles, including the respondent, based on, and to detain them and conduct a productive pat down." And then later on at 205 and 206, he says, "I find not only did they have reasonable articulable suspicion to stop, but the search and the pat down and the flip over gave probable cause for arrest solely in and of itself on the firearm." Okay, and then I just wanted to again point out that Officer Duckett says on direct that it came out and he heard it hit the ground, but then when he's asked on cross, so just to be clear, it's your testimony that the gun fell out as soon as you flipped him over. He says, "I don't recall," so I'd have to see the video if you want to play that, and then I can give you a better statement. And so I think we should really be focused on the video, and we believe that it would be clear error to say there was a frisk prior to the recovery of the gun because of the video.
You believe it would be clear error to say there was a frisk prior to the recovery of the gun? That's not what you mean.
We believe that it would be clear error to say that there was not a frisk prior to the recovery of the gun, sorry.
Well, that would definitely be clear error to say that there was not a frisk prior to the recovery of the gun. I think what you must be meaning to say is that would be clearer to say somebody heard a clang or saw the gun prior to the frisk
Yes,
because you can't see it or hear it on the video?
yes.
I mean, videos don't capture all vantage points. The audio might not be that great. I mean, if I saw something to the contrary, that would be one thing. But I don't know how I could see this and say, well, there's no way that this officer whose eyes are in a different place than his camera couldn't see it.
I think when Officer Duckett himself is saying, I don't recall, so I'd have to see the video if you want to play that.
Sure, I mean, that's a different point. He doesn't actually testify. It's too ambiguous to credit that testimony or something like that. Not that the video makes it a clearly erroneous finding, but that his testimony didn't actually support it.
We believe the testimony doesn't support it. If there are no further questions, we would just ask that you reverse.
Thank you very much. Thanks to both sides for your arguments today and for your briefing, and we will take the case under advisement.